All right. Happy Wednesday. Good morning. Welcome to the Willow Legal Group Coffee Chat. Today we're talking about execution requirements for a will.
Yeah.
So the question came up, right? Can I, if I know I'm dying, or can I write on a Post-it what my plan is? What do I want? Who do I want to get my stuff? And does that work?
Not in the state of Maryland. Now, each state has its own requirements. Some states do allow, those are called holographic wills, and that just means it's handwritten. So that doesn't mean you can't go onto your computer and type up your will, but you cannot handwrite it. In the state of Maryland, it's not valid unless you are an active duty service member and you are deployed, and that's your only option. Those would potentially be recognized. You would still have to prove all the things to meet that exception. But in general, you cannot have a handwritten will in the state of Maryland. So what do we need?
So for wills, you need to have two witnesses.
Mm-hmm.
And best practice, if those witnesses are not relatives,
Mm-hmm.
definitely not named, independent, and all of that. So for wills, that's the bare minimum.
Yeah, they need to be over the age of 18,
Mm-hmm.
and they shouldn't be named anywhere in your will. There's a couple little exceptions to that, but in general, that's what you want to do. The question we get a lot, though, is does a will need to be notarized?
Yeah, and it doesn't need to be notarized. The will document, it is common, right? If you have an attorney or law firm do your will, there will be a page in the back that is an attestation that is for the witnesses and the testatrix to sign, and that gets notarized. And the benefit of that document is if, right, you don't need to go find the witnesses. If there's a will contest, you're not then having to call the witnesses in. That attestation is sufficient, right, with the notary and all of that the will was executed, no duress, everyone was over the age of 18, everything that is needed to validify the will.
Yeah, and your witnesses need to, the witnesses and the will maker, who's the testator or testatrix, depending on whether you're male or female, the person making the will, they should be in the presence of each other when they're signing. So best practices is get everybody in the same room. The person making the will should say, "This is my will," so that the witnesses don't need to read it or anything like that, but they need to know that what they're witnessing is a will. That is one of the legal requirements. And if there's a notary, obviously the notary is going to be there to make sure each person is who they say they are, and that they did in fact sign the document. And like Megan said, if your will is challenged, if somebody says that it's a forgery, if somebody says that you didn't have mental capacity, or somebody was pressuring you to make this will, the purpose of the witnesses is to be able to go to court and testify that, no, I was there, I saw all of these things, and the person did in fact do this on their own. But having that attestation, what if your witnesses have passed away?
Mm-hmm.
What if you can't locate them because they've moved to another state? Something along those lines. So we always make sure that we have that attestation, because that is supposed to be just kind of evidence, additional evidence that, yes, in fact, everybody was here. All the witnesses, the notary verifies that. So while the minimum requirements are 2 witnesses over the age of 18, that is probably not your best bet if you want to make sure your will is considered to be valid.
Yeah. So, and then what about trusts?
So interestingly enough, there's really no legal requirement for witnesses or notary for trusts in the state of Maryland. It just has to be signed. There's some other things, like it has to have the right number of parties. It has to be funded, meaning there has to be something put in it at the time that you create it. And it has to be signed by the trust maker. But again, best practices, we always make sure we have 2 witnesses and a notary, just in case somebody wants to challenge the validity of that trust, or whether the trust maker had the mental capacity to create the trust. So what's legally required and what are your best practices to ensure that things truly happen the way you want them to
Mhm.
are two very different things, which is why, and this just brings me up to the do-it-yourself stuff. Megan's been reviewing some trusts that were created with online software. Not only are they confusing, but they just tell you the bare minimum for what should be required when you print it out and then you have people witness it or you sign it. And that's usually just the bare minimum.
And sometimes the last ones that I was reviewing, right, they just take what's the most common for every state, right? So wills being initialed by all three people, by the will maker and the witnesses. Across everything, or recording your power of attorney,
and
directions on what you're supposed to do and how to record power of attorney, but that's not required in Maryland.
And that actually brings up another point, because if people ask us a lot too, like, what if we move? So as long as your will was valid in the state where it was created. So for example, if you created your will in Maryland and it only requires the witnesses and you have that, it's valid. If you move to another state, that state might require a notary. Some states do. But your will is not invalid. But again, best practices is to make sure that you do have that notary, so there's no question if you move to another state where it does have some more, strict requirements. Yeah. So be careful if you're trying to do these things yourselves, because you might accidentally get yourself into a situation where it's not considered valid because maybe you thought it just needed to be notarized and you didn't get witnesses, or you just have one witness and one notary, which in some states is okay, and some it's not. So you just want to really be careful. And that's why working with an attorney for these things is really a great idea.
Yeah. So, it's confusing, right?
It is.
I've seen ads for a notary recently, and her ads say wills and trusts.
Right.
And so, obviously, or hopefully she's not providing wills and trusts. But, who you wouldn't know. And probably she doesn't know, and she just saw it somewhere and picked it up. But it's confusing.
Yeah, it is. So talk to a lawyer. Make sure that you know exactly what is required before you go out and try to do things by yourself.
Or just don't try to do it by yourself. Because you end up paying us to fix it anyways. And it will be double or more, right? And so, and if something happens to you in between that period, right? I keep reading a lot of these and I'm like, gosh, this isn't what they want. This isn't like what we've talked about for what, these clients' goals are. If something were to happen to them now, and it's what they have.
Right. That's what they're stuck with.
Right.
Yeah.
So don't DIY. What do we have coming up? We don't have.
What day is this? We're in June.
We're getting through the end of school.
Yes.
Thank God. And then so our next event is June 20th.
June 20th. It's another virtual webinar, lunchtime, 12:30, I think. It's another estate planning 101, but this summer we are doing a superhero theme. So it is you'll be seeing ads for that soon. But everything we do this summer is going to have a little flavor of superhero to it. So we're excited about that. And this webinar will also be superhero themed.
Yeah. So, and if you are a client, check your email.
Yes.
And be on the lookout for a special invitation for clients.
Yes.
So we're looking forward to the summer and seeing everyone on the webinar. I'll drop. I don't think registration for the webinar is open yet. If you want to get the email when it comes out, shoot us a message and give us your email if we don't already have it. So that way we can make sure you get that registration link when it comes out.
Yep.
All right. Have a great day.
Bye.